slash detainee. I don't think you will hear the city deny that at the very least this man was detained. And he was going to be put in the squad car. Because it would have been negligent on the behalf of Officer Goins to leave this man in the state that he was in outside. He could have walked into traffic and been hit. He could have gone back in the bar with the knife that he had in his front pocket that they found. We have 2 witness statements from bar patrons that night to support that this guy was a problem. But in the policy it says, the arresting and transporting officer shall thoroughly search each prisoner for weapons and contraband prior to transport. This applies to all transports, including transfers from other officers or agencies. So, we're back to the illegal search, as the city calls it. The search that he lied about, supposedly, to cover up and risk his career, his 9-month career that he had just started, for some drunk guy out in front of the Boulevard Bar. And yet, I just read you from the policy that says a detainee, even before they're put in a squad car, is to be searched. So whether you call it a search or a pat down, and you'll hear those terms interchangeably from Officer Goins because he said he was still using the jargon that he used when he was in DOC for more than 10 years. Now, let me in my last 10 minutes move on. You will hear much said about Officer Goins supposedly not being able to see what he saw that night. This is where it gets really interesting. Extra interesting, Mr. Finnegan. First of all, Mr. Goins, as I said, worked for DOC for 10 plus years. He left voluntarily, had no discipline at all with the DOC, none. Comes here to the city because he wanted to further advance his law enforcement career. He gets hired on March 5th of 2018. As I said, he was a 9-month officer when this event happened. He got terminated on July 22nd of 19 based on a recommendation for termination by Chief Umberger, which was upheld by City Manager Floyd. During his 9 months here, Officer Goins had 0 discipline. 0. He was considered a good up-and-coming officer. And at a time when this department needs more officers, there's a good one right here. City invested money in him to train him. He should be wearing the same uniform the chief is right now. But he's not, because the chief decided to inject himself in the investigation, wasn't at the scene, and says, you couldn't have seen what you saw. He put that in writing. And after he terminated him, and I'm using that phrase, that's my phrase, because yes, the city manager okayed it, boom, rubber stamp. But that's the man that got the train going, as the chief. After doing that, the chief wasn't satisfied. So he then he violates the Gary warning, which you will hear about. This is a U.S. Supreme Court case, that any officer has to come in, answer questions. They can't plead the fifth like in a criminal matter. They have to answer the questions, and anything they say could be used against them for purposes of internal discipline, but will not be used against them for criminal purposes. The chief, not satisfied, and we have the records, and you will see it, had it sent over to the state attorney's office without the state attorney's office asking for it. You will see a letter from Ashley Terwilliger, an assistant state attorney, from February 2020, saying, no, we don't see any false statements here, the basis to proceed forward with any criminal prosecution. The chief wanted to have them criminally prosecuted. He wanted to have Goins and LaFleur criminally prosecuted. Then, he wanted to screw with his certification. You'll see emails from a gentleman by the last name of Kriegsman and Chief Umberger, Public record. Chief, maybe you should pick up the phone. Public record. We have emails from the chief trying to get the FDLE involved. Why would he do that? So he could try to get his certification taken away. And yet you heard Mr. Schroeder say, this is not a chief who was trying to tamper with anything. He not only tried to tamper with the investigation, and he did, he then tried to get them criminally prosecuted on the very IA for which they received a Garrity warning, which said that things that they said in the IA shouldn't be used against them. He sent it to the very agency that could have criminally prosecuted them. Thankfully, ASA Terwilliger saw there was no basis for it. Well, I just don't understand it. The motive of the chief. Now, I suspect, only because I've heard him testify before, he will get up here and give you some grandiose position of his view of the world and his view of law enforcement and how law enforcement officers should be above reproach. Ask yourself, if you hear that out of direct testimony from Mr. DeSrosiers today, did he do the same thing towards this officer? Did he treat him with dignity and respect? He treated him worse than they treat suspects on the streets. Did not give him the benefit of the doubt. Did not trust his own word of a sworn law enforcement officer as to what he saw. No, he doubted it. And then tried to get him criminally prosecuted and have a certification stripped. Now, the last point I want to make about this IA. Oh, goodness. Lieutenant Milan. At his first IA that he admitted under oath for Officer Malera. That one blew up in their face because that one was completely botched. I didn't know it could get any worse, but you're going to see it in this case. It got worse. It's as if they got emboldened by how they tinkered in the Malera IA, and they didn't get called on it, so they took it a step further. It's like a lot of people. If you don't get caught, if you get away with it, push the envelope a little further. Why not? And that's what he did. What was so brazen in this case, as you will see, Mr. Finnegan, is that he literally asked for something to be taken out of an IA. In a July 2019 email, he suggests something should be taken out of an IA. That's illegal. You can't take something out of an IA if it's testimony. He and his deputy chief, who's no longer here, Gary Patton, you will see, and I'm sorry, you know one reason this notebook is so big, Mr. Finnegan? Because there's multiple rewrites of this IA. Multiple. It goes beyond a spell check. Maybe your sentence, you meant this, but is this what you really meant? No. They went from unsustaining him, Lieutenant Milan, not sustained, in 3 different reports you'll see. 3 different times, not sustained. Then when it leaves Sergeant Vasquez and Milan, who are doing their little dance in IA, it gets up to Gary Batten, his henchman, his former henchman. It gets up to Gary Batten, who's now retired. Gary Batten adds some more charges in it, and you'll see that version. Then the chief gets involved, and you'll see emails exchanged between Batten and Chief Umberger. And you'll see Batten saying, I changed what you wanted me to change. Look at the highlights. Look what I've taken out. Is that a fair report? Is that a fair investigation? Again, in 31 years, I've never seen one done like this. Never. Why? Because it's not supposed to be done that way. It's unlawful. You're taking it out of the hands of the investigator and changing the facts to fit a narrative. He knew he knew the outcome he wanted. He knew the outcome he wanted, and he wanted these two officers fired. You'll see versions of the report where they're not sustained, and then once Gary Batten and Jason Umberger get their hands on it, they change and add more charges. And you know what made it, why Milan bears responsibility too as the investigator, is that he violated this officer's rights, and there's nothing they're going to be able to say to deny it. Florida statutes require two forms of verification. The Florida legislature finally, 10 years ago, started adding a little teeth into the IA process. And they said that an IA investigator is to do two things: swear to the truthfulness and swear under penalty of perjury as well that they have not knowingly violated the officer's rights. Until that latest change was made to the Officer Bill of Rights, investigators were free to violate an officer's rights. They at least now have some safeguards in place. And that's under 112.533. And I'll try to finish my time with this. There will be evidence presented that even though they should have learned from Malero, and you'll see that even though they have put both provisions in for an officer named Krashenko that I represented down here, they have both pieces of the required statute. None of the IA reports for this officer have that. Now, why is that important? Why is that important? I'll finish with this. Because there's a statutory provision, and this, it may seem like a minor thing, but it's critically important, and that's why the legislature put it in. I think, as you may know, Mr. Arbitrator Finnegan, under the Officer Bill of Rights, an investigation has to be completed within 180 days from the agency being placed on notice of an allegation or putting the officer on notice of the basis of the reason to do an IA. There are some exemptions for that, exceptions such as an ongoing criminal case, etc., etc. But on 112.533, where it says when a law enforcement or correctional agency personnel assigned the responsibility of investigating a complaint, prepare an investigative report or summary, regardless of form, the person preparing the report shall, at the time the report is completed, 1, verify pursuant to 92.525 that the contents of the report are true and accurate based on the person's personal knowledge, information, and belief. That's the piece that Lieutenant Milan never included. And 2, include the following statement. And that's the I do, the undersigned, hereby swear under penalty of perjury. To the best of my knowledge, I have not knowingly or willfully deprived or allowed another to deprive the subject of the investigation any of the rights contained under 112.532 or 533. Now here's the operative sentence that I want you to focus on respectfully through this case. The next sentence in the law, this is the law of the state of Florida. The requirements of subparagraphs 1 and 2 that I just read shall, not should, shall be completed prior to the determination as to whether to proceed with disciplinary action or to file disciplinary charges. So, the fact that they have never followed the law, ironically enough, of what they've accused him, means that this IA has never been closed properly, and it's well past 180 days, yet he proceeded with recommending termination when knowing, or should have known, he has, they always say there's no excuse for ignorance of the law. I think the chief under oath today on my cross will probably have to acknowledge that. He did in Malero. He can't deny that Milan dropped the ball on this. But then you have to ask yourself, why are we sitting here on December 13th of 2021 and you haven't gone back and rectified it and cleaned it up? You know why? Here's why. Because they know if they clean it up now, they screwed it up. They should have never given the discipline because they blew it. They didn't follow the statute. This case won on that basis alone, Mr. Finnegan. They say he didn't see what he saw. And by the way, last thing I'll say about his eyesight, one thing you don't see in the report, the ASA, and Mr. Williger mentioned it, he was a marksman. He was a marksman for the DOC. You'll see a certificate. He could fire and hit something from 700 yards. One of the certificates in evidence, that will be in evidence, is his certificate as a marksman for the state. I think Milan didn't care about knowing that or didn't give it any credence, and I know the chief didn't give it any credence. But what does that mean? That means he's got better eyesight, that I guarantee you, than any of us sitting in this room right now. He's got better eyesight than any of us sitting in this room now. And the chief, who could have known that from his jacket, his personnel file, is going to tell you that he couldn't see what he said he saw and fire him for that and say you lied? No. Don't let it stand, Mr. Finnegan. I urge you, on behalf of Officer Goins, his wife, his family, he got uprooted, he's had to work out of state. He didn't deserve this. He didn't deserve this. He caused it. The chief did. Don't let him try to tell you it's his fault. The chief caused this. He could have brought him in his office and said, hey, I know you're a 9-month officer. Maybe you saw something. I think you patted him down. Maybe you said search, and it looks like you did you did a search. Maybe you meant pat down. Why didn't he do any of that? None of us would be sitting here in the middle of Christmas and holiday season, nor should we, if he had done his job, the chief. If the buck stops with him, as I bet you'll hear him say, then why didn't it? Why didn't it?
Mr. Wilson, you're over 3 minutes.
I hope at the end of this case, you will see what the evidence will reveal, and that there was no just cause to terminate the employment of Officer Goins, and that also that his officer Bill of Rights were violated. And I hope, Mr. Finnegan, in your deliberations, that you will also come back with an award of reinstatement and back pay, because that's what is justified in this case. Thank you.
Okay, thank you, Mr. Wilson. It's now 10:35 according to my watch. As we transition to your first witness, Mr. Rotary, you want to take a mid-morning break with Mr. Wilson, the same thing, or you want to go right on?
Yeah, it'd be great if 10 minutes.
Yeah, 10-minute break would be great.
Okay, it's 10:35. Let's come back at 10:45, and at that point, Mr.